Do you remember what date that was?
It would have been sometime in the last week of April, perhaps the 26th or 27th of April, 2019.
Would it refresh your recollection to look at a document?
Perhaps.
All right, may I approach Turner?
Your Honor, I'm going to object to this line of questioning as to when, what date, what any particulars with respect to the custody report. If counsel, if this is just a foundation question,
It is.
Well,
leave
the
it up.
question is, at some point, well, the term "at some point" is meaningless. It was completed. And the answer is yes.
Your Honor, the date that we're talking about is just a month prior to the incident for which we're here. And during the state's direct, this time period was especially an interest to the state, as well as Fotis's mindset and the way that he was reacting to the release of the report within this specific time frame.
So if the question is, was it completed on such and such a date, the witness can respond.
Was the report completed on or around April 24th, 2019?
Thereabouts.
You reviewed that report?
I reviewed the report.
You gave the parties the opportunity to review the report?
I offered both parties an opportunity to review the report with their counsel, yes.
But you did not disseminate the report. You didn't make copies of the report and give that out to anybody?
No, I did not.
And that is pursuant to a statute or a court order?
Well, in this particular case, there was no agreement previously by the parties regarding the publication or dissemination of the report. It's my general practice with these types of reports that they not be provided to parties or to their counsel unless there's a court order that limits or controls the dissemination of the use of such a report, because we don't want these reports falling into the public realm in any way. In this particular case, there was no actual court order in that regard, but there was discussions and work towards that. So that's to answer your question.
So you did not disseminate the report to anybody?
Correct.
But the parties had an opportunity to review that report at your office?
That's correct.
Did Fotis come to your office and review that report?
With his counsel, yes.
He was there with Mike Rose?
That's correct.
And you indicated that as a result of the report, he was encouraged?
That's correct.
And without getting into the discussion, did he tell you why he felt encouraged?
Well, that's going to run counter to the protective order. Of course, not going to allow that question.
All right. You had also indicated he was upset and outraged.
That's correct.
As a result of reviewing that report, did Fotis's attorney file a motion with the court?
He filed a motion with the court.
Was that a motion for custody?
I'm going to object, Your Honor.
Well, the fact that the parties read the report, the next question gets into what would be the nature of what he read such that he would file a motion for custody, which gets into the content of the report.
This is my last question in that
It doesn't
line.
matter whether it's the last question. The question is whether it's inadmissible, sustained.
In May of 2019, was it your expectation that Fotis's access to the children was going to continue to progress?
Objection.
Sustained.
In May of 2017, was Jennifer Dulos more agreeable to visitation?
Objection, Your Honor.
Well, in May of 2007,
Of 19, I apologize, Your Honor.
well, if that question isn't covered by the notes, the court is not going to risk having any content pulled from the page of the custody report.
It's not from the
With that
custody report.
question.
Your Honor. You were still the GAL in May of 2019?
Yes.
And you were still involved with parenting and custody issues related to Fotis Dulos?
Yes.
And part of those, one of the aspects of that was supervised visitation?
Correct.
Were you aware that Mr. Dulos was allowed supervised visitation during that period?
Yes.
Was that supervised visitation a little more flexible during that time period?
But just so I understand the time period, which time period are you referring to?
in May of 2019.
The parties had been communicating a little more frequently and with a little more ease.
With a little more ease.
Yes, in regards to his parenting time.
And were you aware that Jennifer had allowed Fotis to visit with the children at her home
Yes, I was aware of that.
at 69 Wells?
Yes.
Following that filing by Fotis's attorney, Mike Rose, in May of 2019, there were court hearings?
Yes.
And were there scheduled court hearings for after May 24th, 2019?
Yes.
You had another conversation with Mr. Dulos on May 25th, or 25th, 2019, or was it 24th, 2019?
I spoke with Mr. Dulos, if I recall, on May 25th, 2019.
And he told you that Jennifer was missing?
Correct.
He also told you that Jennifer had scheduled dental appointments for the kids?
Correct.
And he told you that he was unaware of them?
I'd have to look at the note as to whether or not he was aware of it or
All
not.
right, we're looking at it, refresh your recollection?
Please. Okay, can I have the question again?
You all set?
Yes.
In that phone conversation, Fotis told you that the children had a dental appointment in New York of which he was unaware.
Correct.
And he told you he didn't agree to that?
I don't recall if he said he didn't agree to it, other than just he was not aware.
You were able to check in something called OFW?
That's correct.
Is that Our Family Wizard?
That's correct.
Can you tell the jury what OFW, Our Family Wizard is?
Certainly. Our Family Wizard, also known as OFW, is a computer service, application service that sometimes are used in cases that allows parents to be able to communicate back and forth with each other. And many times when we have cases like we had in this case, we use that as a tool so that we can document when messages are sent between parents, and the guardian is sometimes invited into those communications. As I was here, I can monitor these communications. And it also allows each parent to see if, as and when certain messages, when they're sent, are read. Because many times these involve decision-making issues, need to be done in a timely fashion. And frequently we are met with, I didn't know, I wasn't aware, when we can track that on OFW.
In this case, you were able to track that,
That's correct.
and you knew that Fotis was in fact aware that there was a dental appointment,
Via the OFW message. correct.
and that Fotis had lied.
If that's what you want to call it.
And Fotis lying had been a problem throughout the course of your role as a GAL from 2017.
Again, Your Honor, I don't mean to interfere, but if the questions go into information that would call for me to have to testify about something that was subject to a sealed proceeding.
Well,
I can ask-
at this point, this is now character evidence. And so the code the code states that evidence of a person's character is not admissible to prove action and conformity therewith on a particular occasion. However, there may be evidence introduced as to character for truthfulness or untruthfulness, but that can only be done by opinion or reputation, not at the start by specific instances of conduct.
Attorney Mann, you didn't
So
represent.
the court hasn't finished.
Thank you, Your Honor.
Sustained.
Thank you. You, as the guardian ad litem, did not represent Mr. Dulos?
No.
But you had many conversations with him throughout the course of your representation of the children?
Correct.
Was it your opinion that Mr. Dulos lied an awful lot?
Yes.
When you were speaking to Mr. Dulos on May 25th, 2019, he told you that Jennifer was missing?
Correct.
And you asked him where he was the day before?
Correct.
And whether he had an alibi?
Correct.
And you told him to make sure he had every second accounted for.
I'd have to look at the note again to see exactly what I said.
Do you recall telling him words to that effect?
Again, I'd have to look at the note, Attorney Felsen.
May I approach, Your Honor?
I've had a chance to refresh my
Thank
recollection.
you.
I don't see that in the note.
Whether or not you see that in the note, do you recall having a conversation with Fotis about accounting for his time on that day
I think we had a general conversation about that. That's the reference to the being at home and the cameras, et cetera.
and the importance of doing that?
Well, I didn't give him any instruction of what was important or not.
You didn't give him any instruction at all, right?
Correct.
Because you weren't his attorney,
That's correct.
but you did indicate that he should have his time accounted for.
Again, I don't think I gave him any instruction.
It wasn't an instruction, but you did discuss that with him.
I discussed where he was, what he was doing, whether or not he had an alibi.
Thank you. I have no further questions.
Thank you.
Nothing further. Thank you.
Thank you. Your Honor.
Your Honor, our next witness is actually coming from out of state. They will be here around 2:30. I would ask some indulgence in a longer lunch.
How many witnesses are scheduled for this afternoon? Attorney?
Just one, Your Honor.
Ladies and gentlemen, we'll reconvene at 2:30.
Oh,
Please
wow.
don't hesitate.
Wow. Okay, let's. Well, that's a shocker. They said 2:30. Let's listen to that again.
Please do not discuss the case.
Your Honor, our next witness is actually coming from out of state. They will be here around 2:30. I would ask some indulgence in a longer lunch.
Thank you. How many witnesses are scheduled for this afternoon? Attorney?
Just one, Your Honor.
Ladies and gentlemen, we'll reconvene at 2:30. Please do not discuss the case.
Okay, well, that's quite the shocker. 2:30. Okay. We've got an hour and 10 minutes to kill. So, I think what we'll do is we'll shut this down and we'll come back in 70 minutes. So, wow. Okay. Tune in. Gonna set the alarm in case I lose track of time. So, I will shut this down and we'll start up another stream. And we'll see you soon. Bye-bye.